All right. Thank you all for coming. Good. This is our privacy panel, not to be confused with our security panel that was earlier. As you know, there's a huge overlap between privacy and security, right? There's not a demarcation line. But again, because of that gray overlap, we have some specific privacy questions and concerns that we want to talk to this group about. Let's just go through it and introduce yourself, the organization you work for, and what you do specifically with privacy.
Good morning, almost afternoon. My name is Jamie Danker. I'm the Director of Privacy at Easy Dynamics Corporation. There I'm responsible for delivering privacy risk management services to our clients. Joined in October last year after 15 years in the Federal Civil Service. Past 10 years were at the Department of Homeland Security, where I actually worked with LaShaunne during a brief stint at U.S. Citizenship and Immigration Services, but the last 3 years of my time at DHS, I was at the agency that is now called the Cyber and Infrastructure Security Agency, working on building privacy into the earliest stages of systems development. Prior to that, I was at the Government Accountability Office on the audit side, auditing privacy programs. So I have a real love for privacy and working with privacy programs and actually the system developers to build privacy into the earliest stages of system and program development.
And my name is Jill DeGraff. I'm a partner with Apperture Law Group, and I roger that same sense of passion, particularly around the deployment of cloud-based technologies and the transition to microservices. I love to geek out on what the technologists are doing and then put the overlay of the security frameworks and privacy considerations into the product and the system development life cycles. And so that's what I do in healthcare, focusing as outside counsel for privacy, data security, and the technology transactions through the data supply chain.
And good morning, I'm LaShaunne David. I serve as Privacy Director at the Department of Veterans Affairs, where I've been for the past 7 years. Prior to that, I was, as Jamie said, at the Department of Homeland Security with the U.S. Citizenship and Immigration Services, serving as the Deputy Chief Privacy Officer at the agency. And then prior to that, about 10 years with the Department of Commerce, U.S. Census Bureau in particular, where we actually stood up the Privacy Office at Census Bureau back, I believe it was like 2006 or 7 or something. I'm getting a little dated. So I too have been in this privacy arena in the federal space for some time. I have a passion for privacy as well. And what I will be focusing in on today is how we actually at the Department of Veterans Affairs are working to cultivate a culture of privacy awareness. I was really excited by this morning's security panel and all of the conversation and the ties about the convergence or the intersection between security and privacy. I mean, the landscape has changed, and we're no longer just a compliance outfit. So I'm excited and looking forward to our conversation today.
Let's continue with that. So what are some of the largest, I guess, privacy issues that the VA deals with?
Yeah, so again, referring back to that morning panel, they hit it right on. For me, I would say, and there are several, but if I had to focus on one, I would say baking it right in. I think one of the gentlemen said I shouldn't use that term baking, but I'll use the term too, baking. Baking privacy in, this concept of privacy by design early on from idea, planning, and the requirement stage all the way through assessing for privacy risk and monitoring throughout the life cycle of the program, project, or system.
And I would say that a lot of times people feel intimidated when talking about privacy because they know there are legal issues, laws defining it, and also they realize through various implementations of their own life that it doesn't always yield the same answer, right? So, I think of myself as an explainer, as a team collaborator to be able to demystify privacy in that privacy by design and engineering phase, so that people can build proficiency and confidence. Last week I was at a conference and I was learning about SQL injection, and I was just enjoying that. But then I I made one of these dismissive comments, well, I'm not a technologist, but, and one person corrected me and said, you know what? We are all technologists because we know the technology that we need to know to address our work. And I would say the same thing in privacy, that we are all privacy stewards, and it's really just about being able to develop the shared knowledge domain for us to be able to reason our way through problems together.
So I would add two to that. So I think the two major challenges, one is a communication challenge, and the second, I think, is a resource challenge. And so on the communication challenge, I think there's a clear recognition that privacy and security have this great overlap when it comes to data security. So a loss of availability, confidentiality, and integrity can have privacy impacts, but there's also a problem set when you have authorized uses of data. And to relate that to the resource issue, you don't always have privacy teams sitting down when products are being envisioned to envision, what are the intended uses, but what are also the unintended uses, and how can that cause potential risks to our consumers? And so I think the resources issue is also a real problem in the federal government too. I think information security programs generally are much better resourced financially than our privacy programs. So I think privacy is a little bit at a disadvantage in, we want to keep pace with technology and all these innovations, but really you want to have someone in the room when, like as LaShaunne was saying, at the initiation of a project, so you can identify what are the potential privacy risks. And when the risks are identified, what are the potential requirements we can put in this product or service? How can we apply controls? There are control sets available through NIST guidance in the 853 series that we can use to mitigate some of these risks. But you have to have the resources there for someone to raise their hand and say, hang on a second, have we thought about this?
So as technology advances, right, privacy seems to be diminishing. The new phrase that I've been hearing, and I've basically dealt with security with the federal agencies, and now I'm in the privacy world over at CMS, so it's new to me as well, and I didn't realize how much of an overlap there was. But what I've been hearing is transparency is the new privacy. So what do you feel about that? They just open it up and say, this is what we're doing, and people tend to check that box anyway. And
so, if you don't mind, I'll go first. Disagree. I do not think transparency is the new privacy. I think transparency has always been sort of the bedrock of any good privacy program. But I think the problem that we have today, I think especially in the consumer space, is that we have organizations that are just shifting the risk to the individuals and relying on them to read these very long and complex terms of services that we know folks really aren't reading, and even if they did, they may not understand it. And so I think the new privacy needs to consider risks to individuals, and we need to be thinking about more creative ways to be transparent about uses of their data, and not just rely on the individual to be fully informed. I think individuals have responsibility, but organizations do. I think it's a shared responsibility.
Privacy, a little mnemonic that I use to try to organize its components. There's the disclosure. So you disclose how you're using and how you will share the data and what you will not do with it. There's also the delivery on those commitments that you make. And so those two actually play well together in terms of transparency. So you want to, Apple is a perfect example of a company that has decided to build its brand on principles of trust. And so it is disclosing, but it is also constantly reinforcing its brand association with trust by the way in which it delivers signals to its consumers about how it is protecting your privacy. So I think that, to your point around, is transparency the new privacy? Transparency about disclosure and then your ability to deliver on those disclosures to provide that confidence is a big part of it. I think in addition, you've got, just sort of, I think of it sort of as a privacy moment right now that was ushered in dominantly by Cambridge Analytica, which was not per se a privacy breach because it was all authorized under the terms of use. But but then any number of other prominent uses of data, even under a disclosure regime, where people are finding that their data is being sold without real informed choice, and then also finding out that they're having individual effects through the use of AI, through these large data sets and targeted advertising, and sometimes and the introduction of bias. So what we're really I think, here again, we're at the, a health, privacy, and security forum. We're looking at HHS and VHA or DHA and VA having enormous troves of data and a rising demand to share that data in ways to serve a variety of public welfare interests. But we are now having, the reason we have a moment is that we have to reconsider those silos that we use to protect and now think about new approaches to disclose and deliver trust while sharing that data.
Yeah, I agree with both of you. And I would just add and also reference back to the earlier security conversation. It's important that privacy be at the table, a part of the conversation. Again, earlier there was discussion around business being focused on the mission and, being driven in that way, and then cyber and privacy being perceived as, the police and, keeping us from doing what we need to do. But in reality, if we are, as privacy experts, a part of the conversation and throughout, then we help to create that balance too. As Jamie said, identify the risks along the way, help to mitigate those risks, and just ensure that there is this balance of the two. And the other thing I wanted to say, kind of piggybacking off what Jill is talking about from an informed consent standpoint, and this notion of opting in or opting out, truly understanding that and truly actually having the opportunity to really opt in or opt out. In reality, for example, if you wanted, we were talking before the panel, using Netflix as an example, if you want to log into Netflix and watch movies, as a first-time user, you go through reading the privacy policy or the terms of use. At the end of the day, if you want to watch movies, you have to accept,
do what they want, right.
or you won't be watching the movie. So how much of a choice do you really have? And so I think, just having more, clarity around that, having more opportunities to understand what you're opting in or opting out of, and, maybe truly having the option for real would be, something that would be a good thing.
Right. Okay. Are there any questions from the audience?
Oh, wow.
Nice. All right. I'm sorry.
Hi, I'm Laura with Mantech, and over the years, like going to Health Data Palooza and seeing the Pink Socks Tribe, that's a real hashtag, attend the HIMSS conference in troves, and kind of driving this activist movement of patients owning the data, their medical records. I'd like to understand how privacy might work hand in hand with the patient engaging and being an active participant in their data, as opposed to industry using it for their for-profit purposes.
Well, just to comment on that, I think individual participation has always been a core privacy principle, and so electronic health records, it's really, really powerful for individuals to be able to access their own medical record, not only for the individual, but also for doctors, nurses to be able to share that information and share it securely. But for individuals, I think it's really empowering for them to be able to see what were their lab results, where's my information been shared.
Well, a lot of people will talk about how they are their electronic medical record because they're the only ones who actually have the connectivity with all the diverse providers that they have, right? So and as you know, HIPAA gives everyone the individual right of access to their information. My personal, I've been intensely interested in the NPRMs by ONC and CMS about ensuring that private patient access is achieved without special effort through APIs. And they're providing a very powerful framework to allow that to happen. We'll just have to see. And I will also say, it's difficult to have anyone say they're against doing that. I mean, they're very powerful forces that are going to prevent, that are going to allow information blocking to persist. But I think what we have, and Don Rucker alluded to this in his blog when he first rolled out the NPRMs in February. He said, our job here is to establish the standard gauges, as we did with railroads over 100 years ago, for how the APIs will be used to transmit that information. And it will be available to any app of a consumer's choosing. But once it gets into those services, it's good for the covered entities, the HIPAA covered entities, because there is, if you want to call it, repudiation about their obligations thereafter. But now we're dealing with all sorts of privacy considerations that go outside of the HIPAA realm, and we could actually have a very robust conversation about the lack of adequate protections and transparency in our, in the FTC framework and the fragmented privacy laws that we have on a state by state basis.
Sorry, microphone.
Is the microphone working? Sure. Okay. Jamie, you sort of alluded to this about there are treasure troves of information that are available to us. And the one I'm thinking of is potentially with the Cerner project. If we can follow people from their teens basically to when they pass away, what an amazing amount of research can be done on that information. But one, how do you secure that? And just because you joined the military, does that mean you've given up that to the world, which would be maybe usually generous, but kind of risky? How do you see that happening, and how do you see the Cerner project progressing and sharing that information between active military and veteran status?
That's a good one.
That's a really good one. I will just say from a, control standpoint, privacy controls, we would be making sure throughout that process that appropriate controls are identified and applied, that, we are, taking all the security, obviously the cyber proactive steps that we can to secure the information. But you're right.
There's an effort underway now to try to develop a NIST 853 complement for privacy. And it's very early on, but I think there are a couple of things. One is that the privacy subject matter experts working closely with the security can actually figure out ways of leveraging many of the technology capabilities that are used to provide auditability and the like. The principal issue is that we need to be able to share, but once we have signed the agreement, we don't have continuous monitoring in any effective way, and we need to be able to apply automated technology capabilities in order to provide that monitoring and exception reporting. So maybe an approach would be active, engagement in developing a new privacy framework for controls.
Right. Well, and so on 800, just to add on to the 853, so currently 853 is the Information Systems Security and Privacy Controls. We're on revision 4 currently, which has Appendix J as the privacy controls. And those are very policy, fair information practice principle oriented. It was like a huge step for the privacy community to have these integrated into 53, really helped bridge that gap. But because they're so policy focused, sometimes it's like trying to fit, a square peg into a round hole. It doesn't fully address it because, when you're working from fair information practice principles, I had this when I was working as an auditor, we used the FIPS as criteria. You still have to figure out, how am I going to assess this? How am I actually going to develop a requirement based on transparency? What does that actually mean? And so in Rev 5, which is still hasn't been released yet, I think you're going to see those concepts drilled down at a more granular level and try to make sort of the FIPS actionable, if you will.
Sorry, microphone behind you.
I'll give it to you next year.
And then it's going to come to you.
So Ken Bonner from Unisant, to kind of spin off of what Laura asked, maybe a different way. And that is that CMS has kind of put a stake in the ground 2 years ago and said patients own their data. And that's been a debate. So if patients own their data, then they also then own their privacy. So how is that going to impact how organizations, and particularly federal government, decide how to handle privacy issues? If it's up to the patient, it's their data, they should decide what they do with it, how they do with it, or their caregiver. and you're going to have different levels of understanding among that population that may be educational based or others. How is that going to impact privacy going forward?
I don't think of privacy as a protection of privacy of property rights. I mean, what's implied in that particular statement, and I know what you're driving at. There may be some signaling there that's really about trying to overcome information blocking and a tendency for the producers, the creators of that content, to treat medical records as a business record, right? That is protected as a for competitive purposes. It's really, I think of that as really being where the charge is going. But at the end of the day, I think we have to be really careful that privacy represents some mediation of competing individual and public welfare interests for a specific use case. I mean, there's a reason why we have children's online privacy protection, which is a different regime from HIPAA, which is a different one from federal, education record protection, because we have figured out how to resolve a lot of different complicated issues for specific domains. So it's actually, sometimes that complexity is actually a good thing. But I think when we're dealing with, I think we have to be really careful that we dispel the notion that patients own and dictate all the uses for the information about them. But that's up for discussion.
Totally agree. Anytime the word ownership comes up, as a cybersecurity person, I try to redirect who was responsible for safeguarding the information at the time it was compromised, for example. Mm-hmm. Ownership. If a doctor puts in a House, remember the TV show House, a speculative note, I don't think that, personally, as a patient, I don't want to see that. That would be incurring stress that I don't need because it's not actually part of my health care. It's speculative. So having carte blanche access, getting away from ownership is important. I agree. And piggybacking on the question, there's a chief information officer, there's a chief privacy officer, there's a chief data officer, HR 4174. There's a senior agency official for privacy, and then RMF focuses on the information owner, who's supposed to establish the baseline security controls for information, access controls, et cetera. And yet, I'm curious, your thoughts. Who should have that, I am the tip of the spear for how we assert the inventory of PII, PHI, which I don't think is mandated across the agencies, which is too bad. How we enforce that the information owner is integral part to the assessment and authorization process. It's there in writing. Who enforces, now that 837 revision 2 increased the number of occurrences of the word privacy from 5 in revision 1 to 1,300 in revision 2. So who has that mantle and responsibility to policy and process out the treasure troves of information? Where is it policy that we inventory that data? So who amongst all these people, open discussion, because I don't think it's an easy answer, should have that mantle, that I own it, so to speak?
You want it? These are my perspectives on that. So right now, I believe the reference that I'm most familiar with is high value assets and inventorying, right? And I think that falls under the CIO or the cyber security organization. My bottom line answer on the who owns it, I don't know if one individual could or should. I think there are stakeholders, there are multiple stakeholders within an organization that would have input into that. And so my answer would be that I don't know that I would say that it should be one person's responsibility.
Yeah, and I don't think the RMF dictates who that one person should be. It merely encourages collaboration, and it's going to be, it's not the answer you want to hear, but it's going to be context specific. Sometimes it's the privacy person. I mean, I often find, even if it's a small privacy program, if you're really, really active and involved with your program, sometimes you're the one bringing everyone together. You're asking the questions.
That collaboration, though, if there's nothing that says you have it, it often falls back to the one cybersecurity person that's assessing risk. And the cybersecurity person, with all due respect to myself, I guess, I'm not in a position to dictate what are the access permissions with respect to privacy, when a doctor asks, can I save medical information to the local share drive? I am in no way the person to ask that question to. But to whom should they ask that question? I would say the information owner. But then you have other senior agency official for privacy. So how is that, I guess, what I'm hoping is, yes, I agree in collaboration. How is that collaboration formalized and codified so people say, yes?
Yeah.
That's where you get the answer, because you know it's going to knee-jerk down to the authorizing official, a program manager, or an ISSM.
I can tell you from my experience at DHS in terms of system authorization processes, for the controls in 853, the security controls were under the purview of the CISO, and then the privacy controls were under the purview of the senior agency official for privacy, who's often the chief privacy officer. So there are different accountability frameworks depending on your organization and how your privacy program and how your security program operates. But with the new revision in 853, you're going to have more integrated security and privacy controls. So again, it's not going to say who's responsible.
Right.
It's going to force that collaboration. So it's not going to tell you who, but it's going to force the discussion. And so maybe that's the discussion. You bring all of those parties to the table and say, how are we going to make this work? Who's going to have authority to say, I accept the risk for this control? Who ultimately accepts the risk?
Cybersecurity people are going to die.
Yeah.
Because they know
It's a
that
big
AO
racy
is
chart.
ultimately responsible for the
Right.
acceptance of risk, for that IT to operate.
Right.
Yet we won't have, and I'm not saying we necessarily should, but in the absence of having a similar, there's somebody who accepts the risk of privacy impacts and a certain situation, certain controls, et cetera, people are going to get frustrated.
So who do you think should ultimately be the risk?
Difficult
Accept
to
the risk. I'm going to turn it around on you. So.
But I mean, you're getting at the.
information owner should have a clear role, and if it's not enforced, then we lose an opportunity.
Yeah.
In
Well-
very,
Information owner, if you're saying it's patient's information owner.
I wouldn't
No.
say that.
No, it's within, I think it all ties back ultimately to like the secretary. I mean, this ties back to any organization's mission and how it ties, so data governance and then authorization have to ultimately tie up there and then be delegated. And the delegation can depend upon the particular strengths of your leadership team at that particular time or the maturity of the organizations within those roles. So I sort of feel comfortable with ambiguity of answering, but it raises the point that, so going back to the idea that we're all technologists or we're all privacy experts, we all have to be proficient from the mission level down. We shouldn't have a situation, as I think Sam said, that some breach occurs, but it didn't affect the mission, and they weren't scored against it. We need to change that.
Question? Thank you.
Thanks. I've got a related question on ownership and contracts. So the government works with lots of contractors, and lots of contractors have lots of information provided by the government. I understand that we still have to meet GDPR, California, et cetera. Is that true? If the government gives contractors private information that falls under those regulations, are we still responsible for that protection?
So I think what you first have to look at what the contract scope is. So often that will be delivering service back to the government enterprise. And so the government enterprise is not, so the contractor, if they're not interfacing directly with the consumer, then those laws should not apply. If they are, by contrast, contracted to become an interface for the government or use that data for purposes that are authorized for that contractor to pursue their business mission, then yeah, they would be subject to those rules. And again, GDPR would depend on data subjects in the EU, of course, but in California, it's similar kind of thresholds.
Any other questions from the audience? I have a couple more canned ones. So, Related to protecting the PHI and the Equifax, breach, right? So some of the agencies, Blue Button and others, use these credit bureaus to verify the identity of folks getting onto their systems. Well, now that's breached. Opens up a huge fraud possibility. What are the agencies, VA or private sector, doing to mitigate those type of risks? I mean, even when it's third party, it's not you and your house, it's other folks that you're leveraging.
So what I think government agencies and private sector should be doing is moving away from knowledge-based authentication. Because as we know, how many people in here have been a victim of identity theft or a victim of a breach?
Right.
I know OPM, they have all my information. They probably know all the last 5 addresses. A lot of organizations are still using knowledge-based authentication as if the answers to these questions, it's premised on the idea that that information is private. It's not private. So we need to move away from that and I think move towards stronger digital identity. And there is guidance available with that regard. NIST issued, it's been almost 2 years, the digital identity guidelines, 863. During my time in government, I worked on the privacy requirements and considerations of that, but it's got a lot of great guidance that breaks identity into its component parts. There's a lot of misinformation or misconception about identity that just because I get a text message to my device means that I am who I say I am. There's a difference between identity proofing and authentication, and a lot of opportunities to strengthen identity to protect privacy. At the same time, identity is one of those fun, like double-edged swords where it's, it's a privacy protector, but it's also a privacy risk generator, because you also have organizations that may be requiring too strong of identity proofing when it's not needed, or requiring you to establish an account when it's not necessary. So.
And I would say from a human side, personnel, awareness and training, as it was stated in the earlier panel, most of the threats or breaches or incidents result from, internal errors or, mistakes or otherwise a failure that is from the inside. So really focusing our resources and our efforts around building awareness, training, and again, there was the comment about, well, what is the content of the training? Is the training specific, context-based? Does it relate to an individual in his or her work environment day to day and have meaning? I think that is one of the areas that we're focusing in on at VA. That is to make sure that we have a rigorous, robust training program. We work in coordination with over 400 plus privacy officers or privacy liaisons that, act in some form of capacity, mainly as a collateral duty, but across the VA. We're large, 300,000 plus employees. And so we really do have to focus on, making sure that individuals, not just privacy officers, any individual who works for VA or who has access to VA systems really understands their role, responsibility, and our priority on data protection, respecting privacy, and otherwise basically not being the source or the cause, albeit human error or mistake, of a breach or a possible compromise. So we put a lot of effort and resources around continuing to improve the content, the robustness of our training, and then the checks in between. It was also alluded to earlier, well, you have this one-shot annual mandatory training, and it's like the same thing, and people are just kind of clicking to get through the requirement, right? But it's a matter. Exactly. So, how do we refresh that? How do we make it relevant, the other 11 months, and be specific to an individual and what he or she may encounter? So I would say that would be another way to look at it.
Okay.
I got nothing.
Last question related back to FDA, Afton, and the medical devices. Telemedicine, remote monitoring, very big things now, especially for the rural community and the VA. We talked about it from a security point of view, but from the privacy aspect, how's the VA incorporating, again, language into these medical devices and preserving the privacy, not just the security of that information that's being sent back to the manufacturer or to the health insurance entity?
I quite honestly cannot really speak to that. I don't know from a privacy standpoint how they're doing that. I would imagine certainly from a security standpoint, as the young lady was speaking about during the fire chat, you know, there are security controls and measures that are put in place. I mean, again, I would go back from a privacy standpoint. It's just having that level of awareness. I mean, we do understand that there are, you know, privacy risks associated with, you know, the potential of information being hacked and, you know, what can be derived for that, and certainly the impact on an individual, you know, should their, you know, medical information be exposed and, you know, going through that process. And so again, I go back to just the training, building it in. You know, our training, our annual mandatory awareness training is very robust. We're speaking on just about everything we can think of, and we refresh it to, you know, discuss emerging technology and modernization efforts and, you know, the privacy concerns around these efforts and as we're changing. So I would say the training would be the privacy piece.
Okay.
I used to work for a digital health company with these devices, and so actually I go back to one of your earliest themes around privacy engineering, privacy by design, because we would actually look at the situation that if you were to encrypt every packet of these breadcrumb trails that are going from someone's home up, then you are degrading the service, right? Because it's becoming much bigger payload. So adopting principles of data minimization becomes a way in which you figure out your identity authentication process so that you can minimize the payload and enhance performance. And these similar issues will happen with technologies as well, because you don't want to degrade battery life if you don't have a connection to an AC source. So I think that the considerations really come into play with product design and the role of a privacy expert to be a part of that product development team.
Am I the only one with a wearable on the stage?
Yeah, I don't.
I like my watch. I'm keeping it. I just choose not to share some of my things. So.
Well, I'm sorry. That was all of our questions that we had, canned questions. So that was quick. Go ahead.
I've got a question about what you just talked about. The situation where you have employers telling their employees, hey, if you use wearables or you can, you know, where they're getting people to monitor their health. That kind of is a dual-edged sword, right? Which is, I'm going to wear, if you wear a wearable and you report and we'll give you better health insurance or whatever, but by the same token, they're getting a lot of information about their employees they wouldn't have had otherwise. What are your thoughts on that?
I think about how you can use aggregated data as, you know, pseudonymization, anonymization, all these kind of tools of our trade to protect that. But you also are raising a good point that there are countless examples of how data can also be re-identified. So one thing we haven't even discussed yet are those risks. But again, through product development, participation and things like that. And actually, I think really looking at, there's a lot going on in private industry in how to deal with developing statistical models. There's this one concept called differential privacy, which is a really cool. Are you all familiar with that? A show of hands?
No.
No. Okay. So this concept of differential privacy is that in any kind of a survey situation, and when you're thinking about all this data that's that employees might be contributing into this data set, if you also inject sort of principled dummy data into it, you create a bigger data set. And when you actually start looking, so it ends up becoming harder to re-identify because you've increased the data set to a point where you can't find certain segments and then use it to re-identify. Plus, you're giving everyone plausible deniability that it's not their data because you've now got a bunch of dummy data in there. And so academic researchers are really, and now Google has actually introduced these concepts. I think Facebook and Apple as well are using, like, think about the, so I have an Apple and I get these really annoying crashes, and then I have reports that go out. And if they're, and by the way, when I go into the Genius Bar, they can't actually access that. That's all information that's being used to assist the engineers in improving their product. It's not something that will assist in diagnosing the problem for my particular computer. So if you were to use that kind of a use case, and now they're injecting more dummy data through a differential privacy regime, then they're actually able to show that your confidence levels for any kind of statistics that come out of it are not significantly degraded. But what you, but you also get the advantages from that aggregated data. Was that a little too much in the weeds?
I liked it.
Okay. Some of us. Yeah.
Another question.
Yeah, so kind of taking further my question, like, so all of us have our data anonymized, and healthcare organizations and other organizations are using this data for market intelligence, primarily the pharmaceutical industry. So if my data is anonymized and then it's used in this large data pool, let's say, do I no longer own that data since it's anonymized?
Right, so we don't, when you look under HIPAA, protected health information does not include de-identified data.
So no longer yours once they do
Right.
that. Okay.
Even though it might be able to be traced back to me,
Back
which
to
it
you.
can be.
Right. So on that note, any other questions from the audience? Go ahead.
Should agencies be required to maintain an inventory of PII?
Yes.
So, I mean, I think to some extent that they already are.
Yeah.
With the
Under the
annual
Privacy Act.
FISMA reporting.
Right.
Always, it used to be called Section D. I think it's now just incorporated, not as an appendix anymore. Just like FISMA requires agencies to have a system inventory, there has to be, for every FISMA system, it'll indicate whether or not it's privacy sensitive or not, whether or not there's a Privacy Act system of records associated with it, whether it's operated by a contractor. So there is a modicum of an inventory there, and then depending on the agency, some agencies have really robust processes to sort of do the paperwork exercise to identify what are those assets. Privacy threshold analyses are one tool that many agencies use, maybe used at yours.
Is a network something that should be subject then to? Because, the problem is it's not supposed to be flying back and forth across the network in an email, yet it is. It's kind of a dirty, open secret, really. And people resist a privacy threshold or a full PIA being done on a network or other infrastructure devices.
What?
So the system, the inventory of PII, roger that on systems that are tracked. But there's, you know better than most of us here, all the different touch points that PII might reside in. And how is that monitored when we have, not to overuse, troves of data that now can be saved in the local shared drive because the doctor says I need to do that to save lives? Challenging.
Yes. I think a lot of it goes to how agencies define their systems.
Right.
And again, back to who's responsible for doing it. Is it the information system security manager's job? I think for infrastructure, in many cases, from my time back at DHS, I recall, one of the questions on the privacy threshold analysis was, does this system solely relate to infrastructure? And then there were some sort of tailored questions that would get at some of the items that you're talking about. But I don't know that an inventory would get to all the issues or would mitigate all the concerns you have, like saving data to a shared drive. I think you have to address some of those issues through things like LaShaunne is talking about, like training your workforce about like where it's okay, like SharePoint, for example. I think for agencies, this is always, it's just an example of a shared drive on a larger scale, and it's got the same sort of issues there. It's a training issue. You don't put sensitive PII on a SharePoint site that everybody has access to. So I think training and other mechanisms, not just necessarily the authority to operate process.
And policy, in turn, you set policy around these things, and the SharePoint is a big one, just for multiple iterations of PII under so many different circumstances. Agreed.
There are also, one question I have for those in the government is the extent to which efforts to modernize government technologies is actually going to allow for change management to occur, allow for a lot of the advantages that come from cloud computing and the configuration controls that you can have to mitigate the need for data to be anywhere other than accessible in read or write only mode through a VPN, as opposed to on-premises and other kind of local drives.
Any final questions? Okay, let's thank our panel. Thank you, panel.